Thank you very much, Jez, and thank you to Morty for his warm welcome. And I welcome Ros Croucher, who slipped in a little late, but she is in good voice and she's going to lead us in song later in our session. So let's have a big round of applause for Ros Croucher. I remember the third ALRAC conference, which was held in University House at the Australian National University. It was, to say the least, an extremely fragile time. The government of the Commonwealth had just changed. The dismissal had occurred. A new government was in power. A new Attorney General was there to open the conference. A welcome dinner was arranged by Sir John Kerr, who was a person of some controversy, as the Governor-General at Government House. The former Prime Minister, Mr. Whitlam, was there to see if any of us were being too kind to the new government. And on the whole, we exhibited that feature which is important for the survival of law reform: good manners and understanding where we stand in the constitutional arrangements, that we are there to help and not to hinder or impede or upset the process of law reform, which is a process for the people, not for law reformers, not for politicians, not for governments that come and go, but for the people of our countries. I welcomed at that conference the representatives of so many countries in the region. I think one country which was present was then Ceylon, now Sri Lanka. Sir Victor Tenakoon was there for Sri Lanka. And I welcome all the new representatives of our region and beyond. And in particular, I welcome the representative of the Law Commission of England and Wales, which in a sense is the mother of all the law reform agencies in the Commonwealth of Nations. So Matthew, thank you for being with us. And please bring our greetings back to the United Kingdom and to the Law Commission. A lot of things were happening in Australia and the world on the 1st of January 1975. The Watergate accused had just been found guilty of a cover-up of their crimes and were sentenced to imprisonment, including a former Attorney General of the United States. The Khmer Rouge had commenced their campaign that would lead to the conquest of Kampuchea. The new Constitution of Sweden had just come into effect. In Australia, on the 10th of February 1975, the Federal Attorney General, Senator the Honourable Lionel Murphy QC, was appointed a Justice of the High Court of Australia. In 1973, it was he, Murphy, who had introduced the Law Reform Commission Bill into the Federal Parliament. He said that the promotion of law reform on a comprehensive and uniform basis could only be undertaken by an expert body working full-time on the tasks and removed from the pressures of day-to-day politics. As and from the 4th of February 1975, the foundation members of the Australian Commission commenced office. We were Professor Alex Castles, the first Professor of Australian Legal History from the University of Adelaide, Mr. Gareth Evans from the University of Melbourne, Associate Professor Gordon Hawkins from the University of Sydney, a non-lawyer and criminologist of great distinction, myself, recently appointed a Deputy President of the Arbitration Commission. On the immediate reference to this commission of the task of assessing new laws to provide for the handling of complaints against police and the conduct of criminal investigations by police, which was timed to coincide with a new Australia Police, later to be named Australian Federal Police, was given to the Commission. I was appointed to serve full-time rather than part-time, and the Commission began its duties. Gareth Evans was also appointed for a short time to serve briefly on a full-time basis. He was appointed by me to take charge of the criminal investigation report, and he produced ALRC 2, which is still an outstanding report on the improvement and codification of criminal investigation by police. In June 1975, Mr. F.G. Brennan, QC, of the Queensland Bar, was appointed another part-time member to help with criminal investigation inquiry. At the same time, Mr. John Kane, then the President of the Law Institute of Victoria, later elected a member of the Victorian Parliament and subsequently the Premier, was appointed a part-time commissioner. So this was the core membership of the ALRC. We were a good team. We liked each other. We were proud to serve in this new institution. We got to work in 99 Elizabeth Street, Sydney. A photograph was taken of us. That photograph, now fading, appears in all ALRC events of significance, and I'm extremely surprised that it's not here this afternoon. The five of us are looking rather self-contentedly as we grapple with our new challenge. Only Gareth Evans and I have survived long enough to join in the celebrations of the golden anniversary of the ALRC. The creation of the ALRC was one of several important developments in the law that occurred in 1975. On the 8th of July 75, as Mordy has mentioned, another federal statute had been introduced. Indeed, there were several of them in that year. The first was to abolish Privy Council appeals, and this had to be supplemented later by the Australia Act to abolish appeals from the state Supreme Courts. This was not just idle symbolism, it was the establishment and shifting of the Grundnorm of Australian law to this country, asserting that our own legal system uniquely and locally was accountable only to Australians. On the 16th of September 75, Papua New Guinea won its full independence from Australia under an autochthonous constitution. On the morning of the 11th of November, Sir John Kerr handed Prime Minister Whitlam a letter notifying him of the determination of his commission as Prime Minister. Malcolm Fraser was appointed Prime Minister on condition that he would hold an immediate national election, and so he did. Most of the participants in law reform were full of gloom as a result of those developments of November and December 1975. But they were not paying enough attention to the indications that the new Attorney General, Robert Ellicott, and the new government, in some respects, was a strong supporter of institutional law reform. The policy platform of the Fraser government, including an item promising the referral of new laws to the ALRC, and when I heard that that promise was made and was in the party's political statement for the election, I knew that we were saved and we would survive the election. Mr. Ellicott, after having been appointed, provided a commission with the Commission with a series of important and trailblazing projects full of imagination. These included the reform of the law on privacy, the reform of Aboriginal customary laws, the laws on human tissue transplants, the federal sentencing law reform, insolvency and consumer debt, insurance contracts reform, and compulsory acquisition law reform. Ellicott's list was thoughtful and challenging, a program for the new Commission, and it provided us with a foundation for establishing our credentials before Australia and the world. The Law Reform Commission cannot, of course, control government and policies, personalities of the elected decision makers. However, the events of '75 showed the vital importance of a commission always preserving political neutrality, courtesy, engagement with whoever holds office and however they have secured it. This had to be done professionally and equally with the opposition and minority parties and also independent parties of Parliament. The Commission from the start worked in a context dominated by the executive government and in a country, a federal country, dominated by politics. It's tiresome for those who preceded current office holders to endlessly adulate the way they went about things in earlier times, which were necessarily different from what has followed. The methods which the original ALRC developed and pursued at the outset were suitable for the times when it began its operations. This is not to say that they were conventional or unchallenging. Many of the techniques that the ALRC developed at the outset were quite different from the methods that had followed the predecessors in England, Scotland, New Zealand, Canada and several of the Australian states. In part, the differences pioneered by the ALRC grew out of the federal character of the Australian Commonwealth as required by the Constitution and its history. However, some features of the methodology grew out of the controversial nature of many, even most, of the program items that had been assigned to the Commission by a supposedly conservative government. At the outset, a question arose as to where the Commission should be based. This remains an issue to this day. It was suggested, I suggested, that it would probably be more effective if the Commission were established in Canberra. That was where virtually all of the federal agencies and decision makers were then based. Whilst acknowledging some reasons for establishing the site of the Commission in Canberra, Mr Harders, the Secretary of the Commonwealth Attorney General's Department, made it pretty clear that he was against the idea. If the Attorney General wanted to secure advice from an enlarged group of officers based in Canberra, he would not create a Law Reform Commission. He would simply have enlarged his department, said Mr Harders. The shift of the Commission only because of the residence of a President or of an Attorney General is something that needs further consideration and always on a cost-benefit basis. The venue of the Commission in Sydney soon emerged as an advantage in recruiting highly talented professional staff. These included Keith Johnson, Administrative Officer, Gary Marlberg, his deputy, Ray Hay, my personal assistant, Roy Jordan, and subsequently Virginia Purcell, the initial librarians, a number of highly talented officers, Kevin O'Connor, Brian Kean-Cohen, John Carker, and others who were based in Melbourne, David Bartlett, Sheena Barnes, Bill Turl. All of these are names which appear in equally faded photographs in the office of the ALRC, which I just saw before I came to this event. Although some earlier efforts had been made to create a national body, and I pay tribute to Justice Mears, a passionate Australian, and saw the value of an Australian agency which would include and respond to issues of the states and territories. And although we later built observer status for neighbouring jurisdictions such as Papua New Guinea and had close contacts with New Zealand and Fiji, the engagement with agencies of different states and territories waxed and waned. Within Australia, paying attention to collegial contexts, however, helped to reduce the risks of political hostility and envy that can occur in federations. Great attention was paid institutionally and programmatically to engaging with legal professional bodies, with universities and judicial institutions, and we were soon punching above our weight. Although the budget of the ALRC was greater at the beginning than it later became, the Commission developed economic ways to secure honorary assistance from members of the judiciary, legal institutions, expert academics, civil society and specialised authors. The ALRC ultimately had little difficulty in recruiting part-time consultants to supplement the full and part-time commissioners. They did not, of course, have the responsibility of ultimate decision-making, but in our experience, there was an excitement and an engagement with cooperation because of the inherent interest of the tasks and the manifest utility and practicality of our work. Although inquiries on controversial legal issues, public inquiries, had long existed, such as the Wolfenden Royal Commission on prostitution and homosexual law reform in England, institutional law reform has not generally in the past involved public hearings to supplement the advice of experts. To some extent, this was because of the perceived lack of marginal utility in opening up consultation to interested bodies and the general public. Of course, in some cases, such submissions made at public hearings or elsewise didn't yield marginal utility. However, one of the most important outcomes of our program of public hearings was that they enhanced the profile of the work of the ALRC from the outset. Initially, they increased public awareness of the importance of law reform. They also raised political expectations that results in the form of legal change would happen as a result of the process. Occasionally, politicians and sometimes even attorneys general exhibited hostility to this idea of public hearings. Ultimately, however, there was no difficulty in gathering the public and expert opinions and doing so sometimes in the face of the opposition of departments of state and ministers. In my experience, departmental officials at a later stage didn't have the broad approach and empathy for the Law Reform Commission and for consultations as did Sir Clary Harders in those first days. The reduction of the number and sensitivity of references and the diminution of funding for infrastructure and personnel needs to be overcome was manifest and ever continuing. I see that Professor Marcia Neave, who was introduced as the most experienced law reformer in Australia, I was a bit jealous about that. But let us give her nonetheless a big welcome to our meeting.
Quite unexpected.
Bishop. The English and Scottish law commissions in the 1970s and 80s ordinarily had a particular technique which caught our eye in those first days of the ALRC. It was to attach draft model legislation to the proposals of the Commission. The difficulty of doing so was a degree of professional jealousy amongst parliamentary counsel to anyone else intruded into their sphere. But the greater problem was that of recruiting a highly talented lawyer with experience in the peculiar art of drafting legislation, who could translate recommendations stated in prose into the poetry of legislative provisions. We had an early breakthrough in this respect in the recruitment of John Q. Ewens, John Quiltrew Ewens. He was long-time First Parliamentary Counsel of the Commonwealth of Australia. It was John Q. Ewens who put the first draft of the Communist Party Dissolution Act into place, and that continued and is still in the statute books of the Commonwealth, an act of 1950, but it was struck down in its effect by what was undoubtedly one of the greatest decisions of the High Court of Australia. Anyway, Ewens, who had also drafted other important work, such as the Bank Nationalisation Act, which was also struck down. I don't wish to suggest Mr. Ewens was forward. He was doing what his masters were bidding, but he was a very great drafter. I remember the very day we first showed him Mr. Wang's wonderful invention, the word processor, and how words could actually change on a screen. I saw him blanch at this appearance and thinking of all those times over so many years that he had to have a new start of the whole legislation and retype it. Any of you, I don't like to see people nodding here because that suggests that they remember those horrible days. But that was something which changed before his very eyes. The ALRC's recent reports have not included, typically, draft legislation. Special utility of converting vaguely expressed proposals into draft laws, where every sentence could be measured, was that if a report with recommendations expressed in general language had to compete with the urgent demands of a Minister of State, the use of Parliamentary Council's time and the Commission would have to wait its turn, second best. In the early days of the ALRC, we enjoyed the support of local champions on competing sides of federal politics. Alan Misson, of blessed memory, was a member of the federal Parliament, a Liberal senator for Victoria, but he was a true and faithful companion of the ALRC on many of its projects and spoke up valiantly for us, and that was an important thing. Having champions is very important in a parliamentary democracy. When the Hawke government was elected in 1983, the incoming Attorney General was Gareth Evans, who I understand will be present tonight at our meeting. He is truly a brilliant man, and he was a very effective and important politician, and he played a great role as Foreign Minister in Australia in the development of the international treaties for the control of nuclear weapons, which are now sadly being demolished, but which are essential to our survival as a species. He's a very great man. He'll be here for us for the dinner. He became a vocal champion in Parliament for the implementation of Commission reports. You can't do better than to move from a person who was a commissioner part-time and eventually full-time for a short time, and then who becomes the Attorney General of the Commonwealth and Minister in the government, and a powerful government for the implementation of reports. Immediately on his appointment, he telephoned me in my chambers in Sydney and asked, do you have any reports ready for implementation, pending the preparation of the government's legislation based on its party program? At once, I nominated the report on insurance contracts and the report on privacy protection. He said, no worries. That's something Australians say at such a moment. And he set to ensure that they would both be implemented as they were. Both of them were not small beer. They were both of them very big statutes on very important themes, and they were implemented and adopted. Although he later moved from the Attorney General's portfolio, he never lost interest in and support for the ALRC. With politicians in government and in opposition, the ALRC needs to develop appropriate processes of consultation and information provision, and that applies to all commissions. At the time of my departure from the ALRC for the New South Wales Court of Appeal in 1984, one of the most outstanding reports was nearing its conclusion. In May 1984, an interim report was being produced that would later become the Uniform Evidence Acts of Australia. This is now the daily companion of thousands of judges and lawyers throughout our nation. Those who practice in courts cannot be without a copy of the Act. The project was compiled under the supervision of Commissioner Tim Smith, whose father, Tom Smith, had been the earlier Law Reform Commissioner in Victoria. Two brilliant generations in law reform. Tim Smith, with the support of a magnificent team led by Stephen Hodges, now Senior Counsel, brought the project to completion. They produced a consensus report. It's now in force in the majority of jurisdictions in Australia. After leaving the ALRC, Tim Smith became a greatly respected judge of this state. His widow, Angela Smith, will join us for the celebration tonight. Her presence reminds us of the spouses and partners of the commissioners and staff. They joined the research and administrative staff for regular social events. These included at Emad's famous Lebanese restaurant in Sydney, much beloved by the younger generation of participants. They also included an annual Christmas party at my home on the harbour in Rose Bay in Sydney. Observing the social conventions of those times, my already long-term partner, Johan van Vloten, who has now been with me for 56 years, he was never present, never present. This is the reality of the operation of the law that was brought home to me every day and every night of my service in the ALRC. I came home to my partner and he was a non-person. Legislative reform in New South Wales on sexuality was first adopted in 1984, just in time for my departure from the ALRC. Perhaps it was well timed, but an unconscious tribute to the law reform struggle on so many fronts in Australia to make this country a better, kinder and more modern place. When I departed the ALRC in 1984, the late Justice Murray Wilcox of the Federal Court of Australia was a part-time commissioner, and he was engaged on the Lands Acquisition Act reference. He had been appointed to the Federal Court in May 1984. He served additionally as acting full-time chairman for 9 months. He was succeeded by former Justice Xavier Connor, past Supreme Court Judge of the ACT. Justice Elizabeth Everett succeeded Xavier Connor. She was appointed in January 1988 after Xavier Connor's departure. She served in England under Sir Leslie Scarman in the Law Commission, and that was where she gained her skills in law reform and her passion for law reform. She had acquired great judicial skills. In the meantime, as the Chief Justice of the Federal Court of Australia, she led the ALRC program in 5 areas of law reform: family law, business law, access to justice, government law, and the law in the ACT. Throughout her time, the Commission continued to use the participatory approach, evidencing a view different from that expressed in the earlier days by Sir Clary Harders. The Attorney-General by that time had begun to flex his different muscles. He secured the appointment of senior officers of the Attorney-General's Department, Mr. John Greenwell as Deputy President, and later the appointment of the most senior officer of the Attorney-General's Department, Alan Rose, who was appointed as President, as the top position had now been renamed. Alan Rose was appointed in May 1994. A researcher who'd begun an association with the Commission as a law reform officer, Sue Tung, filled the position between Justice Evert's departure and Mr. Rose's appointment, which was a considerable period. Later, Ros Croucher served for many years as President, and subsequently Sarah Derrington, and somewhere in there, David Weisbrot, Robert Connell, and I think some others were appointed as commissioners. I'm not going to review the entire history of the Commission since my departure and beyond. The Business Council of Australia became a regular critic of the Commission, notwithstanding the efficiency dividends that the Commission paid on several reports relevant to business. A number of public inquiries were instituted at about this time into whether the Law Reform Commission should be abolished as unnecessary to the system of government in Australia. The largest inquiry of this kind was launched in May 1994 by the House of Representatives Standing Committee on Legal and Constitutional Affairs. That report's first recommendation was that the federal government should recognise that there is a continuing need for a commission to carry out law reform functions. It recommended a process of consultation by relevant departments with the Commission. It also proposed that all government departments should make provision by appropriate means for the processing of Commission recommendations. Put briefly, the Commission inquiry represented a qualified endorsement for the continuance of the ALRC. But actions speak louder than words. In an article that I wrote in 2017, published in the Australian Law Journal, volume 91, I demonstrated by a series of graphs and tables the significant and still continuing decline in the number of commissioners appointed, the provision of positive governmental attention to Commission reports, the devotion of adequate funding to the ALRC, and these indicia are incorporated in an index, in an annexure to this speech, which will ultimately be published somewhere. In my remarks in the article, I cautioned against an oversimplistic measurement of the implementation of reports in legislation. For example, Attorney General's Ellicott's reference to us at the beginning of his term in office of Aboriginal customary laws. It didn't result in comprehensive legislation, but it also was ultimately written by one of the Commission's most distinguished jurists from Adelaide, James Crawford, Companion of the Order of Australia. He was subsequently a judge of the International Court of Justice. and he later untimely died. There's little doubt that the ALRC report on Aboriginal customary law, which received the most hits of any report on the ALRC website, had an impact on the zeitgeist, or spirit of the times, that ensued in the Mabo, Wick and other cases. Law reform, you see, often moves in mysterious and indirect ways. The reason for inactivity, or even a refusal of government to consider law reform reports, will sometimes lie with the legislature itself or with government departments and agencies. If management experts were to assess the system of government in all of our countries as it currently operates, I suggest to you that they would be rightly critical about the adequate attention that is given to institutional law reform, especially if there are powerful sectional interests, political apathy, the distraction of other popular issues, or indifference about the problems concerning minorities. Our democratic system in those circumstances will not infrequently fail to yield reform outcomes. That is just how the democratic parliamentary system appears to operate. Indifference to many aspects of law reform is sadly a major impediment to action. The exceptionally high rate of imprisonment of young First Nations people in Australia's prisons, seemingly amongst the highest rate of imprisonment of any group in the whole world, our Indigenous young males in our prisons, was reported on by the ALRC, but effective action has not yet been forthcoming. As I wrote in 2017, hostile forces confronting reform need constantly to be overcome. Optimism and idealism about law reform needs to be reinstated. Tinkering, minimalisation and inertia are just unacceptable. The rule of law needs, and the people of Australia and of all countries present deserve, something better. I congratulate the President and his small team with whom I had a dialogue earlier today. They are devoted to the cause of law reform in Australia. I applaud the innovations that he has introduced, leading to the recruitment of additional staff borrowed from other federal agencies. But this of itself, though an improvement and doubtless extremely helpful, is not really an institutional permanent arrangement that can be a substitute for proper funding of law reform bodies. Back in 1975, if I'd been told that I would be speaking today at the 50th anniversary of the ALRC in 2025, I think I would have predicted that a golden age would have arrived to mark the golden anniversary of the ALRC. This is not a golden age. At best, it's a copper age, or perhaps a tin age. Copper and tin are valuable commodities, but they fall far short of gold. If I am still around, and if after this I am invited again to come back so as to mark my assertion that the oldest law reformer still in captivity, it will be the Diamond Jubilee of the ALRC. It sounds a milestone truly worth surviving for. I hope that the ALRC will then be strong, brilliant and enduring as a diamond is, appreciated for its long-lasting, effective and precious contributions to our Commonwealth. Of course, we who have laboured in institutional law reform should not only blame others for disappointments about commissions. We who are or have been members of the ALRC should clearly honour and celebrate our successes, and I had the pleasure of doing that this morning with the young staff full of hope and hard work that I met at the ALRC. We should share some of the blame for delay and inaction on our own parts. We should face squarely the reality of democratic, social and economic forces that decide the most of the agenda of the actual law making in a country like Australia. We should be realistic in our expectations, and we should strive to earn the diamonds that will, we hope, be ours in the decades ahead.